Alex here with a high conflict child custody video on A Tale of Two Lawyers. And what I'm going to go over is the common complaints that I get that happen to really filter into two sort of different camps. There is the camp that is able to fund litigation and is upset at its cost. And then there is the camp that can't really afford to fund litigation and is upset generally with the results of the process. And I just wanted to sort of go over the different types, those two different types. And at the end, I had some insight that might kind of, trigger a light bulb to go off, for some of my viewers that are having trouble with whatever particular side they fit into. So, with the side of the person who really cannot afford to fund litigation, the complaint that I get is universally, why isn't my lawyer fighting for me? And that typically comes in the flavor of settlement, mediation. These lawyers don't want to litigate. They don't want to go to trial. They just want you to settle your case. They want you to figure out how to work it out. And for anyone who's going through a high conflict child custody case, that's not a realistic solution. And that is because, as mentioned in previous videos, the high conflict X has 99% chance they have a mental health issue, 1% chance they are just severely emotionally immature. And when it comes to that 1%, I don't see why they can't grow out of it over the course of a few months or years. That's typically what happens with people who are emotionally immature. Some of them are slower than others, but over time they do get better. The real problem typically comes from people with mental health issues because they have sort of attached their sense of self, their identity to the conflict, and an end of the conflict is the end of them, as they know it. And so there's this different sort of fanatical approach to continuing the conflict, and that comes from any sort of type of issue where you're drawing your self-worth or your self-esteem from some external influence or thing, rather than internally, like a normal healthy person is going to generate their self-esteem or their sense of self-worth from inside, rather than from some thing that they attach themselves to externally. So anyway, those people end up complaining that they cannot win because their lawyer doesn't even try to win. They aren't even trying to take it to trial. A lot of them aren't even trying to get it through discovery. I've heard of people who complain that their lawyer just skipped discovery, didn't send out a single list of requests for admissions, not a single interrogatory, not even a subpoena. They just told them, hey, yeah, you need to go to this mediation, and you need to go to this one too, and we're going to sort this all out at the settlement conference tomorrow. And when it comes to a high conflict X, they just dig their heels in and refuse. They want what they want, and that's what they're going to have. Unless a judge tells them otherwise, they're not giving up. I can't really go much more into this in the sense of anything new. For the most part, I've covered the consequences of this type of attorney in the video, Settlers versus Litigators. And for the most part, the person who cannot afford to fund litigation gets a settler. That's all that's available to them. An attorney who says, it's $2,000, $5,000 to retain me, and they leave out all the other details. They might sometimes mention, yeah, by the way, if you need to go to litigation or to trial, it's going to cost you another 25 G's. But a lot of them just leave it out. And then if it ends up getting to that point, then they'll kind of drop that on their client. But for the most part, it's very much a sort of a salesman. Some people even say it feels kind of like a used car salesman approach. They feel like they're being sold on the idea of having a lawyer. And then when they go through the process, they're kind of like, this is what it means to have a lawyer? He hardly did anything. Now, all these complaints, as I mentioned, you can look at Settlers versus Litigators. You can also look at Winget Lawyers. You end up with the same problem there. They do hardly any research on your case. They just kind of roll out of bed, go to court, and then right there, they'll meet you 10 minutes prior to the hearing. First time ever, at least first time seriously, or first time after that initial consult. And that's it. Those are your meetings right before court. And that's it. You might get a response in an email from like a paralegal, but you're not going to get anything from the attorney, with that rare exception of right before court, let's talk about it. I think the best benefit from this video is going to come from the other side, from the side that is wealthy, from the side that can afford to fund litigation. And I do get complaints from them in my emails, and their complaints are very different. Their complaint is, why does my lawyer tell me that they're trying to settle a case, and then they send out all of these litigation tools, discovery tools, requests for admissions, interrogatories, subpoenas. They issue like 10 subpoenas to all these different banks that my ex doesn't even use. And sometimes, by the way, they do find money in banks that your ex opened up without, or bank accounts your ex opened up without telling you, and they were hiding money in them. Anyway, it's a very different complaint. It's, my lawyer promised me they were going to work things out. They were going to keep settlement or they were going to keep the litigation expenses as low as they possibly could. They were going to try to settle with my ex like I told them to. And I have paid $140,000 at this point, and it's still not done. And what I can say is they're trying to do their job, or at least they usually are. And the costs end up ballooning because they can't control what the other side is doing. I have heard of a lot of people who complain about the attorneys wanting to continue to fight until everything is drained from both sides, and then they want to just walk away. And I do believe that this is a real thing, but I can't talk about it because, number one, I wasn't one of those people, and number two, of all the emails that I've gotten from my viewers, not one of them has been that complaint. The complaint that I typically get from the other camp is that they don't know why the case isn't settling, and they don't know why they have to pay all these monies because they've been promised that it's going to settle. Well, usually that's what does happen, even with wealthy parties. Usually two people, they're healthy, they're normal, and they want a case to close. And so it can cost more if you both have a lot of assets, because both attorneys are going to want to conduct, forensic analysis on the financials and all that stuff. But typically, it does eventually end once everyone can see where all the money is and once they can get down to brass taxes, I guess you could say. But sometimes one of the wealthy litigants has a high conflict ex, and they have the same problem that the poor litigant has, only their lawyer can at least try to push it through forcefully because they have more assets to their disposal. And it does typically cost that much, especially when you have an incompetent judge on the bench, because an incompetent judge, and that's many of the family division judges, I hate to use that word incompetent, but in my opinion, the ones that obsess over settlement to the point of it damaging the parties are incompetent. And there are a lot of family judges on the family division bench who they obsess over settlement and they will not make a decision. And it's just it's connected to their worldview. Sometimes they have these preconceived notions as to how these things should resolve themselves, and they will impose those opinions that they have on the parties, often to the detriment of the low conflict party and to the great advantage of the high conflict party, because they're going to sort of fake like they do want to work things out, and then behind the scenes they're doing everything they can to sabotage any kind of deal. It comes in many flavors, but that's ultimately the thing that can drive up costs. The only thing that I can say to sort of help both sides understand each other is the side that can really afford to fund the litigation try to understand that it's more a problem with an incompetent family division, an incompetent approach at resolving high conflict cases, and a problem of the fact that you just can't force your opponent to agree. Agreement requires two sides to agree. And if one side refuses, you just can't make it happen. That's not something that you can force to occur. Ironically, the closest you're going to get to a good deal with that kind of person is litigation. And I'm going to talk about that in my next video a little bit more. I've already talked about it in some of my other videos, but I'm not going to go too much into it now. I have another topic. The other side that's asking for their attorney to be aggressive and to fund discovery process and to issue, interrogatories, requests for admissions, send out 22 different subpoenas, and, go into trial with all their guns out. Keep in mind what it really takes for that to happen. I mean, from the perspective of the side that can afford to fund litigation, I mean, it is a lot. It does come to $100,000 sometimes, The lowest it's going to be, the absolute lowest, and that's if you're cutting corners all over the place, is $15,000 to $25,000. And so, and that's not going to make a lot of people happy either, especially because high conflict individuals have a knack for complicating and obfuscating every single issue that's going to come before the court. They make things a whole lot harder to figure out on purpose. And that's because they attach their survival to the conflict. So they have a very strong motive to muddy all the waters, to complicate every single issue that they possibly can. And so oftentimes when you have one of these high conflict debts, you're looking at $50,000 to $75,000, especially since the earlier number that I threw out there, 15 to 25, that just covers a final determination. These high conflict cases, they go into post-judgment proceedings, usually for years, sometimes for over a decade. So you could pay $15,000 to $25,000, and then they could start filing post-judgment motions. Motion to modify child support, motion to modify child custody, and they can do this over and over again. So you can end up having to fork over hundreds of thousands of dollars to get anywhere near the realm of being able to really aggressively fight your case, which is typically what's required with these high conflict cases. The last thing that I'm going to mention is that people need to understand that lawyers are straddling this line. And on the left side of the line is trying to fund the litigation as realistically as possible for the client, for the client who just can't afford it. Keeping in mind that you just do not have the money to do 2 depositions or to issue all those discovery instruments. They have that once on one side of the line is this I better be careful about what I do because I'm not going to get paid because they can't afford it. And then on the other side of the line, they have attorney malpractice, legal malpractice. If they don't do certain things, they can be taken in for a legal malpractice lawsuit. They can be a client can file a bar grievance against them and trigger disciplinary proceedings for them not having done something that under the law they were supposed to do. They've been negligent in how they litigated your case, and they've committed malpractice now. So they have this impossible sort of situation where on one side they have to be really careful because if they do too little for your case, they can be subject to some kind of discipline or liability, financial liability. And then on the other side, they might end up going just too far and incurring so many unnecessary expenses that you find yourself feeling cheated. And that's hopefully, I hope this topic helps my viewers understand that for all of the complaints that you have on your side, there are people on the other side that have been funding putting hundreds of thousands of dollars into their case, and they have a different set of complaints. The real problem here, unfortunately, is some people just can't afford it, and it's just not fair. And that's why I ended up just doing it myself, because I just didn't have a choice. I just couldn't afford it. I represented myself because it was either that or just not even try. For me, it never was how much can I put into an attorney. For me, it was always don't even try or go it alone. And I chose to go it alone. And I don't know. I hope that if you have any questions, any comments, if you have any insight that you can provide, post it down in the comments below, because this is I think this is a tough topic, but I think it resonates with a lot of people who have attorneys. And I'm kind of surprised that a lot of people who come on my channel do have an attorney, and they're there to try to understand what's going on. And they just have a different perspective from those of us who are representing ourselves. I mean, for all the troubles that we go through, for all the strife that we go through, money isn't really one of them, because we don't have a lawyer, so we don't have to pay one. Anyway, I hope this, like I mentioned earlier, I hope this video is useful for my viewers. And as I mentioned earlier, go ahead and post something down in the comments below if you think you can help the other viewers, and I will see you guys next time.